Keep an eye on your YouTube and let me know when it's running. That sounds like the one I did earlier.
Yeah. Be a loading signal.
Well, and that's what I'm getting here.
Okay.
And that's what I've got each time. It's reached this certain point. Usually the red line goes all the way across the screen and it opens up a window and shows me that it's live streaming.
It's not loading.
It hasn't. It hasn't all morning.
Well, it kicked up the last one you did.
It just kicked me off. Let me try it again.
Okay.
And I'm going to shoot Jeremy a quick email. See if they're having troubles. I started to do that earlier when you told me that that it was playing.
I don't know why it picked up one. It also shows 3 live streams on your channel right now.
What he says. Yeah, it's just timing out.
Hmm.
I think we'll just go forward without it.
Okay.
Okay. Let's see. Size more. Well, I don't see either of those attorneys here. That tells me it's likely they resolved. Let me check my email. All right, I'm gonna guess they worked theirs out. We'll hold on to that for now. Adkins. Well, I'm having trouble figuring out who's who. I'm just gonna let everybody in.
Morning, Your Honor.
Morning.
Morning, Judge.
Good morning, everyone. I'm having trouble figuring out who's who this morning, so I decided to let everyone in, and I'll just call the cases. Shannon, put us on the record now. Okay, is anyone here on the matter of Sizemore versus Gibson? Like we're still waiting on a couple of audio connections. All right, just judging from the names on the file, I don't think anyone is here on that matter. Is anyone here on the matter of Atkins versus Taco Bell Corporation? Okay. Well, if this continues, I'll get through my docket much faster than I thought I would. Baker versus Keelhorn.
Yes, sir. I'm here for the plaintiff. This is John Turk speaking.
Turck, Shannon.
Wait a minute, I didn't get that.
John Turk on behalf of,
The plaintiff, Anthony Baker.
And this is Mitch Jackson on behalf of some of the defendants, including Dr. Monfett, Henry Ford Allegiance, and IEP. My co-defendant has brought the motion. I'm not sure if co-defendant has appeared yet.
Atkins versus Taco Bell. Oh, no, I'm sorry.
Yeah, I didn't think it was that one.
Baker versus Columbia Medical.
I got an email saying that this was taken off the docket.
I don't have that on my docket.
Ah. So apparently the moving party removed it from my docket at the last minute.
Yeah. Apparently Attorney Hackney said that they are canceling their motion tomorrow in the above matter.
All right.
So I'll remove it from the docket.
Well, I'm glad you didn't have to drive far to attend the motion hearing this morning, gentlemen.
Yeah, that works out well. Thank you, Your Honor.
You're
Here you go,
welcome.
no-
Have a good day.
You have a good one.
Take care, Judge. Thank you.
All right, next up is Snyder versus Arnold. Do you have that, Shannon?
I do have that one.
Defendant's motion to compel. And I do not see either counsel for this file. We are making great progress. Graber versus Farm Bureau. Doesn't sound like anybody's here for that. Airway Welding versus Rogers.
Good morning, Your Honor. Bruce Inocencio and Christina Fisk, both present for the plaintiffs. I do not see that defendant's counsel, Joe Spiegel, is present.
All right, we'll pass on that one then. Milling versus Gilbert. Folks, you can come up to the council table.
Your Honor, Brad Berlinski on behalf of the plaintiffs on that matter.
Just have a seat, folks. I'm getting some feedback from somewhere. If you're not on this case, please mute your microphone. So I'm for sure, what is your name?
So my name is Ladarius Gilbert.
Okay, did you get that, Shannon? And ma'am, what's your name?
Kelly Gilbert.
Okay, so we have two items on my docket this morning. One is a motion for entry of a default judgment. And then the response to that apparently was a motion to set aside that motion.
Well, I think it was the default entry, Judge, is the way I read it. There was a default entered, and now we're seeking entry of the default judgment.
Your Honor,
I just a second, sir. 720. Give me just a second. Well, in any event, let me hear from the defendants. What is your objection to entry of the default judgment, sir?
Based on, Your Honor, that everything is paid off, it's void ab initio, based on the fraudulent act based on the plaintiff.
What fraud are you talking about, sir?
Well, Your Honor, for one, during the pandemic, I had got served while I was incarcerated, and my wife got served out here. So at the time when we were supposed to be responding, court closed. And when we was looking on the site, it was always saying that the court was closed, the court was closed, the court was closed, the court was closed, until we got this summons. So me and my wife, we took it upon just to make some calls and come to find out that we can come. But it just had opened on that Monday.
Okay, so I understand what you're saying, that because of COVID, you were delayed in filing a response. So that might provide a basis for one prong of what's required to set aside a default. But the other prong, you have to show a reasonable cause for why you didn't respond in a timely manner, and that addresses that. But the other prong that you have to show is, do you have a meritorious defense to the foreclosure claim? Do you have a reason for why you haven't, according to what was filed, you had a balloon payment that was due in January. That means the whole balance came due. At that point, your obligation is to pay off that balance. Normally that happens by going and getting a loan. You borrow from a bank. They give you the money so that you can get a mortgage on your property and pay off the land contract. But you haven't done those things.
We couldn't do it, Your Honor. Absolutely. You absolutely right.
Why couldn't you do it?
Come to find out that the plaintiff is saying that he's the lender when it's a mortgage company. We can't even, it's not even our home. We can't even own it because he owns the home through a mortgage company.
Give me 1 minute. I went to 3 different financial institutions when I spoke with Ken and explained to him that Ladarius was coming out in May, and I said, please allow him to come out in May, and since both of our names are on the land contract, we'll attempt to get the loan at that time. He said no. I said, I'll continue to keep paying you the $850 a month, just allow him to come home. He said no. I then reached out to Fifth Third Bank, Huntington Bank, and CP Credit Union, who I personally have banked with for years. When I started to go through the loan process with them, immediately they come up on the assessor's website and they say, well, we show with the record of deeds that you guys are already the owners. So therefore, you don't qualify for no first-time homeowners programs. You don't qualify for FHA loan. They went through this whole scenario, what we didn't qualify for. They then proceeded to tell me that I could not proceed any further because per the language of his loan, which we have a copy from the certified copy, it says that he is not to put his house on a land contract while he has a mortgage on the home.
So if you got a loan approved for the full amount of the land contract, what would happen is his mortgage would be paid off first, and only if there's something left after that would he get anything else. But
they would not even do a loan for us. They kept saying it was a refinance on his loan. And we're saying, no, why did we want to refinance his loan?
And another thing too, Your Honor, we have Carmen Sherman, the chief operating officer of the
Members First Mortgage.
the member for his mortgage. She even went through us, but she couldn't release no information. So we like to submit this in as evidence as well that this plaintiff, he did this stuff to us, and now the things that we did never own the home, Your Honor. So by us not owning this home, it was sooner we start saying, let us see the stuff about the mortgage so that we can take it to our bank. You know, That information did never get revealed to us.
This lady wanted to know how long.
Hold on a minute, hold on a minute. You didn't own the home outright, but you owned a purchaser's interest in a land contract, which gives you the right to buy the home as long as you make the payment.
We was making payment. We never stopped making payment.
The problem is it had a balloon payment. A balloon payment means all of the balance has come due. In order for you to fulfill your part of that land contract, you have to pay off the balance when it's due.
And that's what we was telling him, that circumstances happened where at the time when he asking for it, I'm incarcerated. So it's no possible way, Your Honor, that I can enter the bank. So those are the material circumstances that I'm presenting to you. There's no way that I could have did it. I can't go from prison to the bank. I cannot do that, Your Honor.
Mr. Berlinski?
Your Honor, thank you. Good morning. Incarceration is not a defense. And regardless, the request was delayed till May. Here we are, August. He still has the ability, they both still have the ability to obtain financing and to pay this off. That's all my client wants, is to be paid off. This is a very straightforward matter. It's a 2-year land contract with a balloon payment. As the court has indicated, the court is well aware of the situation of these types of arrangements. They're very common. The balloon payment came due. That was in January. There can't even be an argument that it was during COVID. And it was not refinanced. And we chose to move forward. Defendants were properly personally served before the stay-home order. The stay-home order was in effect. There was a stay. We obviously abided by that stay. We did not move for a default entry until July. We waited the applicable time period that was required. We counted the days for each defendant. The default was properly entered by the clerk of the court. I believe it was July 13th. The defendants had adequate time to respond. They could have called the court. The court could have told them the options for filing. During the pandemic, I was filing things. It didn't prohibit me from filing things. One of the defendants, as noted in the response, actually called our office twice about the case. She was well aware of the case. That shows that she was aware of it. She could have called the court. She actually went to the court at one point, or called them, but she went to district court clerk. I think she was under the impression that it was an eviction case, but it's not. It's a circuit court land contract foreclosure case. The defendants have the ability to redeem. This is a long process, as the court knows, even longer with COVID. And we still have to publish, and then there's a redemption period after a sheriff's sale. So they have adequate time to obtain financing, even after today's date and after the entry of the judgment, Your Honor. So we've followed every rule required of us. As the court indicated, there's a 2-part requirement of good cause and meritorious defense. I don't believe that the good cause has been met based on the items that I've addressed, both orally here and in the brief, as they had adequate time and to file a response and chose not to. The second prong has clearly not been met. There's a balloon payment, and they haven't paid. They admitted they haven't paid. They're having trouble getting financing. They need to seek some assistance in that regard in order to make that happen. But we've followed every proper procedure and law to have this default judgment be entered. We've provided a courtesy copy to the court in advance and also to the defendant. Plaintiff would ask that defendant's motion to set aside the default, is what I'm classifying it as, be denied for the reasons argued this morning and in the response brief provided to the court yesterday, and ask that the motion for the default judgment be granted. Thank you.
Either of you have any more to say?
Yeah, I'm gonna object to that because I called the court numerous times and nobody ever answered the phone for me to file my response. In turn, I would then talk to my husband on the phone, and he was told by Michigan Department of Corrections that the court was closed and there was no way to file a response. So It wasn't until the court was open when we came downstairs and we were at the civil window that that lady had me call his office, which is what he's referencing to. And that's the same day that we went around the corner to the clerk and we filed that motion to set aside. So I called several times. I even called the gentleman who gave me his card when he served me at work. And he said, there's nothing you can do, the courts are closed. When I was served was March, I believe, 3rd or 4th, and I have 21 days to respond. It was my 19th day when you folks closed, because we were trying to both file at the exact same time.
So as I stated at the outset, in order to set aside a default, you have to have good cause for why you didn't answer. You've got good cause because of courthouse being closed, et cetera. But you also have to come forward with what's called a meritorious defense. That means a defense which, if true, would keep the plaintiff from being able to foreclose on your land contract.
Well,
The only defense you've given me is that Mr. Gilbert was incarcerated.
okay, well, Your Honor, well, like I said in the beginning, that it's like, I mean, this is a court of truth. You know, the wording of things, I'm not a lawyer, Your Honor. I'm not. We're trying to do the best of our ability with what we have. And the word you saying that meritorious defense.
Meritorious. It means a good defense, a defense for why you shouldn't have to pay this land contract in the manner that it says you were supposed to, which is in January, you had a balloon payment due and you didn't pay it.
Yes, sir.
And the reason you gave me for not paying it was you were incarcerated. And that doesn't qualify.
We was under the impression you were saying a response. That wasn't, I wasn't under the impression that you were saying that the payment could be made. What I was under the impression that you was talking about while we can respond.
No, so let me try to say this again, okay? There is a proper basis for setting aside a default. You do it by filing a motion to set aside default, which you did. And in that motion, you didn't really say why, but you told me here today, the reason you didn't answer timely is because the courthouse was closed. So I can give you that. I can.
That's not what I'm saying, sir. I said in the motion that it was based upon a fraudulent act.
Oh, I saw that you wrote that, but you haven't identified a fraudulent act.
Okay, now, in the court of law or with contract law, right, there's a certain thing that all parties must agree to a contract.
Yeah.
Okay. Now, all parties wasn't made aware of what was done, meaning
I've got a signed land contract.
This bank did not.
This bank did not have knowledge of what the plaintiff, Kenneth Millen, was doing. Your Honor, they said that if they would have knew this, Your Honor, that we wouldn't even been in here because they would have got the property from him.
Whether or not the sale on a land contract was a default under his mortgage is a separate issue. If we were here today with his mortgage company trying to foreclose and get you out of this property.
The company's not trying to foreclose.
I know they're not. That's why that's not an issue.
No,
Look,
but they will be because they said, they wanted to know, I spoke with Carmen yesterday. She
all
wanted to know how.
all they care is that they get paid. So here's what's going to happen. I'm not going to grant your motion to set it aside. I'm going to grant his motion for entry of a default judgment. And here's what's going to happen. He's going to go through the steps of publishing the sale. Once that's done, and there's a notice out there that the property is going to be sold, you can even show up at that sale and make sure it's done properly. But once there is a sale, you then have 3 more months to get a bank to finance you, and as long as you come up with the money to pay whatever's due on his land contract, you will be able to redeem and keep your house. You've got time to do it, but you've got to come up with the money to pay off the land contract. There's no excuse for not doing that the law is going to recognize. Non-payment, whatever hardship caused your inability to pay it is not a defense to having to pay off a contract. So you are going to have time. I would advise you to keep talking to whatever lender you can and see if you can get, if they'll loan you the money to pay off this contract, that underlying mortgage will be paid before the plaintiff in this case is paid, because he's obligated to deliver you clear title. That means that mortgage has to be taken care of out of the money that you pay him. And if you're able to do that and you've got time now, you'll get 3 full months after this sale goes through in which to get it financed and to salvage your house if you can get it financed. If you can't, at the end of that time period, you're going to lose it. And there's nothing else I can do about that, folks. The law is the law. I have to follow the law.
Okay.
Mr. Berlinski, you'll submit your proposed default judgment?
I submitted it with the filing. It should be in the court file.
Hold on a minute. Let me make sure of that.
Because things have been done by Zoom, I've been trying to submit the orders in advance.
All right, I do have a default judgment, so I'll be signing that today. You will be served with copies of this. If you'd like, I can get you a copy right now. Okay, they'll mail it to you, and get with whatever lenders you can. If they'll loan you the money to pay off this contract, you'll be able to save your home, and you don't have to worry about that underlying mortgage. It'll have to be taken care of. So you'll get the property free and clear, except for whatever mortgage you're able to obtain to pay off that balance.
Anything else?
Okay.
Not interested in you guys. Go away or else I'll sue the fuck
No,
out of you.
this
I'm not shitting you.
Final judgment.
this is the final judgment right here.
That's it. Good?
That concludes this hearing.
Thank you, Your Honor.
Is anyone here on the matter of Graber versus Farm Bureau? Oh, I think I called that already. Never mind. Pardon me. I grabbed from the wrong stack. Knutson versus Gassert.
Good morning, Your Honor. Eric Kaiser on behalf of the plaintiff, the Knutsons this morning.
Good morning, Judge Christopher McNeely on behalf of Dean Gassert.
Okay, and I believe this is plaintiff's motion for a preliminary injunction. Is that correct, Mr. Kaiser?
That's correct, Your Honor.
I've read the motion. If there was a response, I didn't see it.
Judge, just for the record, I was on vacation last week and my client was served late last week. We had been dealing with getting service over the past month or two or 4, actually, since this was started just before COVID. I haven't had an opportunity to fully review everything or to file a response, so I don't think that it would necessarily be appropriate if the court is inclined to grant any relief. I've briefly read the brief. There's some procedural issues that I would object to, but they admit that basically this is the same motion as the one that was brought by the township, and that there are minor changes to the basic claim, but it's still basically the same claim. Which, if you'll recall, we had a conference call a month and a half ago with regard to consolidating these two cases for discovery purposes. So I would object with, necessarily going forward immediately if the court's inclined to grant it. I mean, I don't think that they meet the four-prong test anyway, but there's also a pretrial set for today.
Your Honor.
Well, I could tell you I wouldn't be inclined to grant any form of injunction that closes down Mr. Gassard's business, but I am sensitive to perhaps a limited injunction to move his vehicles back sufficient distance from the roadway so that the plaintiffs can safely get on the highway.
And this has been previously raised with the Department of Transportation, Judge, and they've come out, and I don't have, an opportunity. I can show you the letter from the Department of Transportation last August that addressed it, and they have 26 feet from the white line that Mr. Gassard has complied with. So I think that the parties have an issue with standing. They're basically trying to usurp the state's Department of Transportation's rights to enforce the right of way and the visual guidelines that are required and sight lines. I don't think if you'll even look, it's probably moot at this point anyway. You see any of the pictures that are attached to the complaint, they're covered in snow, things like that. And one of the allegations I think that I read was that it was plowed as snow into a spot that blocked their view. So I don't think that there's a particular issue right now that would require any kind of an injunction.
May I respond, Your Honor?
Go ahead, Mr. Kaiser.
In regards to the service issue, I will tell you that Mr. McNeely and myself have been exchanging emails since March. I had contacted him knowing that he was representing Mr. Gassard on the Columbia Township matter and asked him if he would acknowledge service. I sent him a copy of the summons and complaint. However, the summons did not contain the backside of the complaint, and he refused to accept service at that time. Back in March 16th, I believe, was when that first email was sent. They've been very aware of the complaint, very aware of the content of the motion for quite some time. The issue as far as timing, beside the fact that Mr. Gassard was served timely before this hearing, as far as 7 days, as far as the court rule indicates, they've also been very aware for several months. We didn't conduct the preliminary injunction because the business was not operational during the lockdown orders, and we knew that the court was not going to issue an order based on the matter that was before the court with Columbia Township to shut down Mr. Gassard's business. However, what we are asking for today is exactly what you indicated you were inclined to do. The setback requirements are not just something that involve the Michigan State Highway. The Columbia Township zoning ordinance requires minimum setbacks for all commercial business, not just car dealerships, not just C1 or C2, but all commercial businesses have minimum setback requirements, Your Honor. If you look at page 6 of the complaint, or page 5 of the complaint, I cite all of the minimum setback standards in the footnote for the complaint and motion that are contained on page 5 and 6. It talks about C1, C2, and GO districts and how the minimum setback needs to be 35 feet from the roadway. That's for buildings, and it goes on to say, section 7.18, that all open air businesses, which a car dealership is, that all outdoor sales, storage, and display areas shall comply with the minimum setback standards for the building on the premises. It's not just a snow issue, Your Honor. The snow issue was just brought up to bring to the court's attention Mr. Gassard's seemingly animosity towards my client, is that even when he's still encroaching on the roadway and blocking their view, he was doing everything in his power to impede their view of the traffic further. Those cars are still in place. They're still in front of his building, which is not allowed by the zoning ordinance. They don't comply with the minimum setbacks from the roadway. They don't comply with the minimum setbacks from the property line, which is according to the statute or the zoning ordinance, which is 30 feet away from, or the 10 feet and 20 feet when adjacent to an agricultural or residential district. So that those cars need to be backed up 20 feet from the property line as well, Your Honor. This applies to all commercial businesses in Columbia Township. It's a car dealership issue. We would ask for a preliminary injunction that says that Mr. Gatzert has to abide by the buffer areas and the clear vision zone that's present in the township based on business. And I do believe it meets the four-pronged test, right? I think we're likely to prevail on this issue, that my clients are continuing to suffer harm and put themselves in danger when they're leaving their roadway, and the public at large, or leaving their driveway, and the public at large is susceptible to accidents occurring at that area. It's not a very visible area, and it's right where the speed limit changes from 25 miles an hour to 55 miles an hour as you're leaving the village. So there's potential here for there to be an accident just based on the fact that people can't see past the cars, Your Honor.
If Judge, if you're going to continue with this hearing, I do think that there's a great lack of evidence. Even if the ordinances apply, even if the setbacks require the 35 feet, we have no evidence. We have no tape measure out there that shows that 35 feet. There's no evidence whatsoever that they produced that my client is in compliance with all of those items. So to say that they carry the burden, which they have a significant heavy burden for a preliminary injunction, I think fails on its face. I don't disagree with the concept of safety issues being something that would be at issue, but that's not at issue. And the state has specifically, and the township has had an opportunity to raise this issue. Obviously, they sued my client with regard to the zoning as a whole. So I think that to issue any kind of a preliminary injunction without at least an evidentiary hearing or some other greater evidence for the plaintiff to carry their burden would be a completely unfair and unjust result for my client.
All right, here's what I'm going to do. I am going to enter a preliminary injunction requiring the defendant to comply with section 13.4 clear vision zone as cited at the bottom of page 6 of the plaintiff's complaint. I will certainly entertain further modifications, but I think at a minimum, I could tell from the pictures clearly that the vehicles parked right up to the curb are going to create a hazard for somebody trying to exit from an adjoining driveway. And I'm not going to make a finding, and I'm not going to make a finding of where exactly those vehicles are with respect to the center line. I'm simply ordering compliance with section 13.4.
Which becomes unfortunately a subjective issue. So it, I think it invites a continued issue, because if my client goes out and measures and my client goes out and we take pictures from, down by the driveway of the adjoining property, and I can look at it, and I'll be out there on Friday. So that's exactly what I'll do, is to make sure that the court then, just so the court's aware, that's where this will end up going. I'm sure I understand the court's ruling, but I want to be, very forthright. And we didn't get the brief for this motion until last week. So although we've been playing phone tag and email tag, I just want the court to be aware that we weren't dragging our feet on this.
If the defendant does not comply with the injunction, there's certainly a risk of sanctions, including contempt of court. Mr. Kaiser, you'll prepare and submit that preliminary injunction.
I will, Your Honor.
Thank you.
We also
Okay,
have a
looks like
pretrial, Judge?
I've got some other, well, we're so early in the process. I'm going to give you a new pretrial date.
I think we probably need a whole case scheduling order, Your Honor, given that.
Yeah, clearly, it's going to have to be adjusted. If you two gentlemen can confer about what would be a reasonable schedule and submit with blanks as to a new pretrial and trial date, I'm happy to accommodate that.
Judge, we were combining the two cases with regard to discovery.
Okay.
And I see Mr. White is here, and we were looking at entering an order. I think discovery expired in July on the previous case, on the township case. But we were looking at, until I was properly, served and could file an appearance, I wasn't getting that order out to consolidate those. So now that I have apparently all of the pleadings and I'll file an appearance today, we'll file an order to that extent. Do you want that to be a part of that process? And Mr. White, are you agreeable to talk about that with Eric and I with regard to dates? That makes sense?
Of course, I think that only makes sense for some judicial economy.
I agree.
Yeah, I'm fine with a consolidation of the two matters. It makes sense. There's common issues of fact and law raised in both. It certainly makes sense. So you can do an order consolidating, and then an order setting a discovery schedule, and then leave blanks for a pretrial and a trial date. And when you send it in, let us know what would be a realistic pretrial and trial date to set for you, and we'll try to accommodate that.
Great, Judge. We'll take care of that.
Okay, thank you, gentlemen. Have a good day.
Thank you, Judge.
Okay, I think we've got everyone here on Rogers versus Rogers. Counsel, could you state your appearances, please?
This is Joseph Spiegel. Roger, this is Airway Welding versus Rogers, or is this a different Rogers case?
I have different, some pleadings start with Rogers and others start with Airway.
Okay.
You know the case, Counsel.
Yeah, it's Joseph Spiegel for the defendants, Ricky Rogers, Brian Rogers, and Brett Rogers. Sorry, Your Honor.
Good morning, Your Honor. Bruce Inocencio and Christina Fisk on behalf of the plaintiffs.
Good morning, Your Honor.
Okay, so this is counter plaintiff's motion
This
to
is-
compel, correct?
Your Honor,
Actually, Your
before
Honor,
we,
this is plaintiffs.
Your
This is
Your Honor,
plaintiff's
before
motion
we,
to compel.
right, before we start, a couple of housekeeping matters. I did get a hold of Mr. Anderson as a potential third director. I felt that we had a very good, pleasant conversation. He was going to talk to his partner and get back to me. He charges $250 an hour, and I sent to Mr. Inocencio a letter asking what his view of Mr. Anderson was. And I have not heard back from him. I just briefly told him what the nature of the matter was and that you had referred us to him. So that's item number one. And then item number two, I've attempted to re-engage Mr. Soretsky for a third try at settlement. And I am hopeful that that's a possibility. You know, third try is, always good. So that is the status of those preliminary housekeeping matters. I could not get a hold of Mr. The other gentleman. He has been retired for about 4 or 5 years. I could not find a phone number. His old law firm did not have any contact information for him. I did find, I'm sorry, one phone number, but it was disconnected. So I think Mr. Anderson would fit the bill as a third director, and my client approves.
Your Honor, may I address those issues preliminarily?
Sure.
Thank you. To begin, we are not interested in proceeding with a third director. Essentially, what we have here by reference to a third director is an acknowledgement by the defendants and counter plaintiffs that a third director is needed to break a corporate deadlock, which is essentially what we have been suggesting has happened and specifically alleging has happened in our complaint. And there's no question that there's a corporate deadlock. We do not want to engage a third director and have to pay that person to come in. I think there's a number of issues here that would be created by engagement of a paid third director that does not have any experience with this business over the past 35 years. So we're going to decline the court's offer to entertain that possibility as some type of an outside of the box option and move forward with the case as we have prepared it thus far. With respect to the second point from Mr. Spiegel relative to re-engagement of the mediator, Mr. Soretsky, I did speak with Mr. Soretsky about 10 days ago, and he contacted me after having been contacted by Mr. Spiegel, and I asked him to reach back out to Mr. Spiegel. I called Mr. Soretsky again on Thursday, and he told me that he had not yet received a return call from Mr. Spiegel, even though he had followed up with him after I spoke with him. So from our perspective, the ball is in the defendant's court to return that call and have the mediator contact me thereafter. So moving forward.
I did get a hold of Mr. Soretsky, Bruce, and we had a pretty good conversation. And essentially I said, just give me a number and what it will take to get, Doug out of the company. And we're kind of waiting for you to give us a number. And once we get that number, I'm not going to discuss any numbers. The case would be over possibly if my clients accepted Doug's number, but we don't have a number from you. I've asked for a number in the past. If you don't want to give me a number, I'll try and get Mr. Soretsky to move it along and possibly maybe we could get the court involved in a settlement conference in the next couple of 3 weeks.
That's not going to happen, Your Honor. Let's move forward with the motion to compel. I don't want to go down this road with the settlement. Also ask for the same information from defense counsel. We're here today for the motion to compel. And here's what's happening. Discovery does not stop because someone files a motion. And that's what the defendants have suggested should happen in this case, that this court should somehow hold off on requiring the defendant's witnesses to appear for depositions or respond to subpoenas in the event that this court might possibly grant a motion. Your Honor, before we go into any detail relative to the merits of the motion, I am cognizant of the fact that this court does not enjoy entertaining motions to compel. And I would hope that the court understands that we recognize that and that we have waited and waited and waited, and we've sent 3 amended notices of deposition. We were asked to engage in a telephone conference to discuss the scheduling of these depositions. We did that. We agreed with all 4 attorneys on the phone to dates in July. And shortly before those depositions were to have moved forward, we were met with another excuse for delay. At this point, the motion to disqualify that's been filed by defendant's counsel is the only reason that we are aware of that these depositions have been delayed and the hearing has been scheduled for August 13th. Interestingly, the rationale for delaying the depositions is that there is a possibility that if this court should grant the motion to disqualify, which by the way, we think has no merit, the defendant's argument is that if our office was somehow removed because of a perceived conflict, that the plaintiff's new successor counsel would want to be the attorneys taking the depositions. While we appreciate defendant's counsel looking out for our clients' interests, we've discussed that with our clients at length, and they are not concerned. And so they have wanted to move forward with these depositions for a long time, and so have we. I just checked this morning the amount of time that my firm has spent dealing with these discovery delays, and it exceeds 30 hours. between phone calls, emails, responding to letters, responding to arguments that essentially have no basis whatsoever. Here's where we are. We sent a subpoena to an individual by the name of Adam Kelly and his business Data Exam LLC after we learned that Mr. Kelly was at Airway Welding on July 2nd, 3rd, and 4th and was somehow involved in obtaining data from computers at Airway Welding. We were unaware that this was happening. We were told that on those same days when we wanted to conduct depositions, that the defendants were out and about, that they were unavailable. Well, in fact, Mr. Spiegel and Mr. Kelly and the defendants were all at Airway Welding in the afternoon of July 2nd, doing something relative to those computers. That's not how discovery is to be conducted, lying in wait by some type of ambush. We have no idea what Mr. Kelly obtained from those computers, and we're entitled to know. There is no legal basis to say that the subpoena should not be complied with, and this court should order that Mr. Kelly, in fact, respond to the subpoena. Mr. Kelly is not an expert witness. He's not been listed as such. What has happened here is the defendants are suggesting that Mr. Kelly is a discovery consultant. He was engaged, according to Mr. Spiegel's correspondence to our office, by Mr. Spiegel to conduct electronically stored information searches of company computers, not to prepare or develop mental impressions or conclusions or opinions or legal theories of the case. He is not an expert witness. His efforts are not protected under the work product privilege. We are entitled to know what data was collected, what was deleted, what was viewed, or was otherwise accessed. We can't get that from any other source except for Mr. Kelly. This is a substantial need. There's undue hardship here without question. Mr. Kelly is the only person that knows that information. Mr. Spiegel has decided for some reason to direct Mr. Kelly not to comply with a subpoena that we have issued under the authority of this court and the applicable court rules. We want this court to order Mr. Kelly to respond.
Mr. Inocencio.
We also need the depositions to move forward. Yes.
Your client has full access to the computers that this person accessed?
He does. The concern here, Judge, is that my client and the rest of Airway closed for the 4th of July holiday on Thursday, July 2nd at noon. The following Monday, when Mr. Rogers, Doug, specifically Rogers, showed up at work, a message popped up on his screen that he had never seen before, suggesting that some type of software tracking was installed on his computer. We don't know exactly what happened. We also know that there were banker boxes removed from the building, and at least one of the defendants left with a duffel bag, which we presume to be documents. We don't know what Mr. Kelly did. We need to know that. That's important to us. We have been stonewalled over and over and over again relative to discovery. And now what we have is we have an individual engaged by an attorney to go in without any advance notice to us, without our knowledge and consent, and to gain access to our client's computer. I have no idea what he saw there. I have no idea if he has access to attorney-client communications. There's been a suggestion in the supplemental documents that were submitted late last night via fax by defendant's counsel with this new case that was just released from the Court of Appeals, that somehow if there is an attorney-client communication on company email, that it is not protected by the confidentiality rules. That only applies in two scenarios. You have to have a company policy that's published, and you have to have disclosure of that company policy to the individual that seeks protection of the attorney-client privilege. There is no company policy in this case that says that employees have no confidentiality and they should be subject to disclosure of those emails. So that case does not apply at all. It has no basis in fact or legal relationship to our facts. Relative to the depositions, There is no reason at all that we can see that these depositions should be adjourned. They need to move forward later this week. We have scheduled these, and every time we do, we get another excuse, another delay. I've never seen anything like this. We've now sent a third amended notice, and then all of a sudden another motion gets filed. Every time we schedule these, it's one more thing. I don't want to belabor it, Your Honor, but I think in this circumstance, costs are appropriate and sanctions are appropriate.
Your Honor, I must say a couple of things.
May I finish, please?
Hold on, let him finish.
Thank you. We would ask that the court order that the defendants and Sue Rogers appear for the depositions that have been noticed up for this week via Zoom per counsel's request. And also that Mr. Kelly of Data Exam LLC be required to comply with a subpoena by next Monday at noon. And also that the defendants pay costs and attorney's fees in the amount of $10,000.
Your Honor,
Thank you.
Very briefly, I have been practicing 45 years. I have never had a situation where counsel refuses to call me to agree to deposition dates. And yes, we agreed to certain deposition dates. And then there was a disclosure that Mr. Inocencio wants to take his former client's depositions. And he, without any consideration to anybody, including his former clients, noticed up the depositions just before the motion for disqualification. And we said, if the motion is not granted, we will appear on the 19th and 20th or the 26th and 27th. And we would agree to an order to that effect. Because if Mr. Inocencio takes the depositions of his former clients, he's going to get the relief he wants with respect to objecting to the impression of impropriety in suing his former clients. So we just put it over for a very short period of time to allow this court to make a ruling. Now, if the court makes a ruling that says there is no conflict under 1.9, and keep in mind, Your Honor, 1.9 changed in 1988, but putting that aside, then we're going to need a protective order so that we know that Mr. Inocencio is not going to violate 1.9 and confidentiality. So that's item number one. He cannot, and he did it intentionally. This wasn't an accident. He never called. He did it on purpose. He did it the minute he realized he may not be able to take the depositions. And that is what I consider inappropriate. I should be asking for sanctions, but I'm not going to on the basis of comedy, as I said in the reply brief. So that's item number one. And we'd agree to a order with respect to the depositions on the 19th, 20th, if it's okay with those dates with him, or the 26th and 27th, if it's okay with him. We have produced 10,403 documents with almost 40 different categories and written responses to his discovery requests. And the only thing we asked was he let us know which of the 10,403 documents he's going to use during the deposition. That's the only thing we asked. So to say that we have not cooperated in discovery is absurd. With respect to Mr. Kelly, exhibit number 8, I have not installed any software on airway welding computer. Mr. Kelly works for me. If I want to look with my client on those company computers that are owned 50% by my client, they're absolutely entitled to do that. And I attached as exhibit number 10, the IT person for airway welding, Mr. Unita Networks LLC. Where's a declaration by him? Why haven't they said, okay, we inspected the computers, there's no software on here? The reason is They don't have any evidence. And Mr. Innocencio has never had any evidence of any wrongdoing, never produced any evidence, not one scintilla. So let's assume for the moment that my clients wanted to look at their own computers and they wanted to image those computers to look at them carefully. They have an absolute right to do that. Your Honor, this is absurd because we have been bullied from day one. We didn't file this lawsuit. We didn't want this lawsuit. The company has $1.3 million. It's making money. Everybody's happy. The employees are productive. And let me tell you something, Your Honor. What really upset me is he told you that the company couldn't distribute $800,000 for each of the two owners. He said it would ruin the company. 3 days later, $750,000, $750,000 was distributed to each of the owners. That is just one example of misleading this court, and he intentionally set out to do so. He has intentionally tried to bully my clients, his former clients, and all we're asking is a 10-day delay in the taking of depositions so this court can determine whether or not he has an irrefutable conflict of interest. He hasn't even responded to that motion. And I believe the court is fully capable of making a ruling on August 13th. And once the court makes a ruling, we'll either get a protective order or Mr. Innocencio and his firm will be out and some other lawyer will have to become familiar with the case and they can take the depositions and we will cooperate. And for example, we said to Mr. Innocencio, we will agree to any extension of the case management order, any extension, which is reasonable. So we've produced 10,403 documents. We've agreed to depositions on the 19th and 20th of August before the motion. We have presented evidence that no software was put onto those computers and Mr. Innocencio's client's IT person can look at the computers and make any determination and provide any kind of report because we are absolutely convinced that nothing was deleted, nothing was taken, and they were just looked at. And finally, Your Honor, there is a company policy. Those computers were bought and paid for. And I can provide record evidence, bought and paid for by the company, each and every one of them. So this is a frivolous motion. It's a motion to bully. We didn't file this lawsuit. We have a likelihood of success on the merits. We want to keep the business going. And the only reason we suggested to the court, and the court agreed to have a third director, so let's see what happens over the next 6 months. We're in a pandemic. The country is in an economic crisis. Why do they want to dissolve this company now? What is their objective? What is really going on here? Because what I said to the court was, if Doug wants to retire, he can walk away and still get 50% of the profits. He can make $750,000 a year by doing absolutely nothing. All he has to do is walk away and let Rick Rogers and his family run the company, which they've been doing for 30 or 40 years. Because those 10,000 documents, and I don't think Mr. Innocencio is going to disagree, will show beyond any question that Rick Rogers, Brett Rogers, Ryan Rogers are responsible for 85% of all the money that's made for the company. We didn't start this case. We don't want this case. We don't want the company dissolved. It's making money for the citizens of the city of Jackson at a time of economic crisis. And I'm not going to ask for sanctions for the frivolous. He refuses to call up and say, let's have a discussion about this motion to disqualify. You know, Bruce could have told me from day one he represented those people in the past, but he didn't. He held on to it in this. And I think that is just outrageous. It's outrageous. If I'd known that before, we could have done something different. But no, he never disclosed it. And yeah, my clients didn't disclose it in timely basis. They were absolutely mortified by the whole thing. So I respectfully request an order setting the depositions the 19th or 20th or the 26th and 27th, obviously assuming you make a ruling, which I believe you will. And I want a protective order, which we can discuss after the, on the 13th. And finally, there's absolutely no legal, factual, or any other basis for taking the deposition of one of my consultants, and a consultant that is working for me, because he did make mental impressions, and I don't have to tell anybody what those mental impressions were. That's an outrage, and he knows it. This is just bullying, abusive discovery tactics for no reason whatsoever. Thank you, Your Honor. I'm sorry I got upset, but this is ridiculous. We shouldn't be here today.
Your Honor, may I respond very briefly?
Go ahead.
Thank you. To begin, the defendants are not my former clients in total. I represented Ryan Rogers approximately 20 years ago on a criminal matter.
It was 14 years ago, it wasn't 20.
Well, I don't even remember representing him as far as what the charges were, what happened. I did not represent all these defendants. And if I may, Your Honor, I didn't interrupt Mr. Spiegel. I think it's inappropriate that he continues to do that. Nevertheless, let me finish, and I will be brief. This entire family were not my former clients. I represented Ryan Rogers, I think right after he was graduating from high school or right when he was about to graduate from high school. I don't even recall exactly what the issue was. Nevertheless, he and his brother and his parents, the people that are being represented here by Mr. Spiegel, have known about this conflict that they're suggesting is a conflict, which we do not believe is a conflict, for over a year and a half, and they've done nothing. The suggestion here is that we schedule these depositions on the heels of filing their motion to disqualify. Your Honor, that's a lie. That's flat out a lie. It's very apparent from the court file. You can look to see when I first scheduled these out for a deposition and the times that we continued to amend the notices. They didn't file their motion to disqualify first. We filed 3 separate amended notices. Then they filed their motion to disqualify. What Mr. Spiegel wants this court to do is take the position that we're only taking this approach because he filed his motion to disqualify. That's completely false. This is a date we agreed on, Judge. We have a copy of the transcript from the call. He requested that we have a call. On June 29th, we agreed to that. We had the call. And we agreed to these dates in July. A month later, we get ready to have the depositions, and he files this motion. With respect to the 10,000 documents, yes, Judge, I'm going to have to take Mr. Spiegel at his word that yesterday afternoon, when he delivered a thumb drive to my office after hours and left it on the front porch, that there's 10,000 documents on it. A couple days ago, he sent a letter that said that those documents had been mailed to my office. I don't know how they got here, but there's a USB drive that shows up last night with apparently 10,000 documents on it. So to say, has he delivered those to us? Yes, apparently he has. Have we had an opportunity to see them and do what he wants us to do, which is to tell him in advance the depositions which documents we're going to use? Judge, if we're going to use a document during a deposition, we'll certainly let him know what that is, but he just delivered them to us last night. The depositions are supposed to happen later this week. This is preposterous to suggest that we are somehow doing something that we should not be doing. We're taking depositions. We're entitled to that. There's something out there that they don't want us to know. And every time I've had to file a motion to compel, since I've been practicing law, what I have found is this. If someone doesn't want you to go forward with the discovery, it's because there's something that they're hiding. And I don't know what that is, and I don't really care. But we need to get to the bottom of this case. And the fact is, I cannot do that. And the defendants have no legal reason to say that we should not be able to go forward with these depositions. Under 2.313A5A, we believe the court should grant the motion to compel and impose an appropriate sanction. Thank you, Your Honor.
Your Honor, if we didn't want the depositions to go, I wouldn't say let's do them on the 19th and 20th or the 26th and 27th. That is absurd. We've got nothing to hide.
All right,
As Mayor Daley said,
I've heard enough from both counsel. I'm going to compel the depositions to occur either on the 19th or 20th, or the 26th or 27th. That will give me a chance to hear arguments on a motion that I'm very skeptical about, but I at least want to get a formal response to it. With respect to the discovery expert, he certainly should be compelled to indicate what exactly he did with the computer. If he imaged the whole computer, that's enough. I imaged the whole computer. I imaged the hard drive, whatever. If that's what he did, he ought to have to say that he did. If he chose to image something less than that, he should be ordered to say what he imaged. I'm not going to get into why he imaged what he did, at whose request, at whose decision, but he at a minimum ought to be able to be compelled to answer that. I don't think a deposition is necessary for that. A simple verified statement, this is what I imaged, and yay or nay, did I install any software on this computer? He should be compelled to answer that.
no problem, Your Honor.
I am not awarding any sanctions. Mr. Innocencio, you get to pick which of those dates you want to go forward on. You can include that in your order.
I will, Your Honor. Thank you very much. We appreciate your time.
Thank you, Your Honor.
Okay, Blake versus Morris.
Morning, Your Honor. Thomas Barger on behalf of defendants.
Get that, Shannon?
Yes, and good morning. Kevin Miller appearing on behalf of Haley Blake, the plaintiff.
Your Honor, this is my motion to withdraw as to representation of the defendant Logan Morris. This is a dog bite case that was just recently filed by the plaintiff, Haley Blake, I believe on May 29, 2020. When I received the assignment in error, I filed appearances and answers on behalf of both Sharon Morris and Logan Morris. Since that time, I have learned that my sole client in this matter is Sharon Morris, and that the appearance on my behalf of Logan Morris was due to an administrative error. I had the opportunity to speak with Mr. Morris as I set forth in my motion on July 8th, 2020. I explained the circumstances to him, advised him that I would be filing this motion, served a copy of the motion upon him, and I have not heard anything since. I am simply asking that the court permit myself as well as my firm Hackney Grover to withdraw from the representation of Logan Morris. As I put in my motion, I am requesting that the court give Mr. Morris, if my motion is granted, 60 days to determine if he needs counsel, if he is going to retain counsel. So I'd ask that I and my firm be permitted to withdraw as to defendant Logan Morris's representation.
Is there any objection to the motion?
I don't object to them withdrawing. The only thing that I would, instead of 60 days, days, I would just say 28 days. He's already been served and should have tried to have already gotten an attorney. But I don't have a problem with them withdrawing if they're not going to represent him. Now, I'm not going to hold somebody in the case that they're not going to be working for, so that's fine.
All right, I'm going to grant the motion, and I am going to grant 60 days. These times, it's a little harder to get business taken care of for replacement counsel. Mr. Barger, you'll submit that order?
I will submit the order, and I will also.
And it's by phone. I don't have video.
Mr. Morris and advise him of the court's ruling in the 60 days. Thank you
very much.
Appreciate it.
Thank you, Your Honor.
You're welcome. Have a good day. Next up is Big Vision versus Ferry. I'm going to take just a short break, and I'll come right back out on the record. I'll leave the meeting room open.
An Ostrander?
No, this is Bank of America and.
That's not me.
That's not you.
No, I'm on Ostrander.
Because your number, or the office number keeps popping up.
I'm on, here's the case number. Bob, we don't do Bank of America comes here. I mean, you can give him the case number that I'm on, it's Ostrander. Okay. And then I'll need that back. If you want me to stop him.
No. No. Oh, okay. Oh, no problem. No worries. Because your number was popping up on a Zoom screen, but I don't know. I don't know why that was.
And I don't even know what number came, because we can't select our numbers now. So it just randomly selects one of our phone lines to go out on. So I don't know. In fact, do you have a list of our phone numbers? I'd ask Mary Jo to get me one.
Yeah, I can do that.
If you would, please, so that way I can. There's 4 or 5 lines that we have. There's 2620, blah, 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 blah. I need it. I know we've had the list, but I thought there was a list up front.
Okay, Big Vision versus Ferry. Council, state your appearances, please.
Good morning, Your Honor. Brendan Beer on behalf of Big Vision LLC.
Good morning, Your Honor. Christina Fisk on behalf of the defendants Charles Ferry and Choice Chiropractic, PLLC.
Go ahead, Mr. Beer.
Thank you, Your Honor. Your Honor, this morning we're here on what I think is a relatively straightforward motion for issuance of a preliminary injunction related to the defendant's violation of a agreement that he signed, which is attached and included within my motion. I'm sure you've seen it. It's confidentiality, non-solicitation, and competition agreement. You know, I'm sure you've read my brief, you've read Ms. Fisk's brief. I don't want to belabor issues, but I do want to bring a few things to light. If you look at the agreement, which is attached, again, as I said, as Exhibit A to my brief and support, at the bottom of the first page is the language regarding the covenant not to compete. And a lot has been made of this language, and specifically the language that discusses the business relationship with any doctor in the state of licensed in the state of Michigan. It says employee agrees that during the term of employee's association with the company and for a period of 2 years from the date of termination of said association for any reason, he, which is obviously a type, shall not engage in, whether as a proprietor, partner, stockholder, lender, director, officer, employee, joint venture, investor, lessor, supplier, customer, or other participant in any business relationship with any doctor licensed in the state of Michigan within 12 miles of any area in which the company shall be doing business. Mrs. Fisk has responded to that argument by essentially saying that that language does not prohibit defendant Ferry from starting Choice Chiropractic and opening an office less than a mile from my client's office, his former employer. And frankly, I find that a little bit preposterous. I mean, when you look at that language, and then you look to the argument made within Ms. Fisk's brief, she actually writes, while defendant Ferry is arguably prohibited from working for another local chiropractor, chiropractic office owned by another chiropractor or purchasing an ownership interest in same, there is nothing in the agreement to suggest that he is prohibited from starting his own practice. And so the idea is that he can't go to work for another chiropractor. He couldn't partner up with another chiropractor, but because he's on his own, it's okay. And the idea is that she says it's literally impossible for defendant Ferry to enter into a business relationship with himself. Your Honor, people do that every day. That's what a sole proprietorship is. You enter into a business relationship by yourself and you engage in business. That is what a sole proprietorship is, and the word proprietorship is specifically enumerated within the clause. And what's more disingenuous about this is the background behind this agreement. Dr. Ferry was presented with this agreement because Double Chiropractic had an office in Morenci, and a chiropractor who was employed by Dr. Double in Morenci left and opened an office directly across the street. And so Dr. Double came to Dr. Ferry and said, hey, before we get too far into this, if you're going to work for me and I'm going to help you to build a practice and to engage and learn how to be a chiropractor and train you and show you how this business is done, you're at least going to agree that if you leave, you're not going to solicit my patients and you're not going to open an office that's competitive with mine within 12 miles. And he signed it. He knew exactly what he was doing when he agreed to this agreement. He knew exactly that this was the type of behavior that was prohibited. He has left and he has done it. He has opened an office right down the street, less than a mile away. And so that you don't get confused by the addresses, Your Honor, both these offices are on Spring River Road, 0.8 of a mile apart. And he has not even attempted to comply with the 12-mile radius requirement. He has completely thumbed his nose at it. He didn't go to Parnell Road. He didn't go to Brooklyn. He didn't go to Napoleon. He didn't go out onto Horton Road. He opened an office 0.8 of a mile down the road on the same street. And then here's the next thing. After he does that, if you look at the agreement, it also contains on the next page, if you look at my exhibit A to my brief, which is the agreement in place. On the next page is all the non-solicitation provisions. And I'm sure Your Honor could read them. And I don't have a clue what the issue is there, but they're there on the second page of that covenant is attached. It basically says you can't solicit employees from Dr. Double, you can't solicit patients from Dr. Double, and you can't try to entice these people to not work for or do business with them any longer. And he's done all of those things since he's left. Since he left, he hired the former massage therapist for Dr. Double. He sent a postcard attached to my brief to all of Dr. Double chiropractic patients, directly soliciting them to join him at his new practice. And I mean, when you look at it, it couldn't be, frankly, more egregious. It actually has the language that, and this is, I'm specifically referring in my brief to what has been attached as Exhibit D. This is the postcard that was sent to every patient Double Chiropractic has, hoping they'll make a choice to leave Double Chiropractic and join him at Choice Chiropractic. That was brought to us by a patient. And he says, oh, in his brief, in his response, Mrs. Fisk says, oh, he just sent them out to the general public. He made them to Double Chiropractic patients. That's not true. That is not true. And I know it's not true because I've already been told that he recollected where they were off the internet or something like that, because I suggested that when he left, he stole the patient list, which frankly would be a HIPAA violation. And so now this is the tactic they're taking. But ask yourself this, how did he know where to send all these things so that every patient of ours would get one? Every patient of Double Chiropractic would receive this. How has he been able to service these patients since he left without requesting even a single patient file from Double Chiropractic? None. Because he took all that information with him when he left in the night. when you look at this, he doesn't even deny it. He acknowledges that he sent this information out. He acknowledges that he sent the postcards. He acknowledges that he hired Dr. Double's former massage therapist. He's never requested a patient list. Dr. Double has tried to make appointments after he left with patients, and they told him, we already know that Dr. Ferry's leaving, we know where he's going, and we're going to be joining him in his new practice, which means he was telling patients while he worked for Double Chiropractic that he was leaving, that he was going to be opening up a new office, and where it was going to be, as he's treating them in Double Chiropractic. The law on this case, and you can see it, I've cited it, and frankly, Miss Fisk, Christina Fisk, doesn't even seem to respond to it. It's very clear. Restrictive covenants are enforceable in Michigan. You can read the statute MCL 445.774A that says an employer may obtain from an employee an agreement or covenant which protects an employer's reasonably competitive business interests and expressly prohibits an employee from engaging in employment or a line of business after termination of employment if the agreement or covenant is reasonable. This one is very narrowly crafted. We're not telling Dr. Ferry that he can't work as a chiropractor. We're not telling him he can't open his own chiropractic practice. All we're telling him is he can't solicit patients from Double Chiropractic. Can't steal employees from Double Chiropractic, and he has to open it up 12 miles from the current office that he works in. He could have gone to Brooklyn. He could have gone, he didn't even need to leave Jackson County. And instead of making any effort to comply with this agreement or honor the agreement he signed, he just left like a thief and opened an office in just about the biggest violative way he could get this agreement. He made zero effort to try to comply. It's not like he went 6 miles and he's trying to argue that 12 miles isn't reasonable. Because of the way he's gone about it, the reasonableness of the covenant is even really in dispute. I mean, we could have made it a mile and he would have violated it. He just made no effort whatsoever to comply with the agreement at all. And when you look at this agreement and you look at the cases that I've attached the case that in Michigan is the seminal case for the enforcement of a restrictive covenant in the medical setting. The Court of Appeals, St. Clair Medical, and I may slaughter this, Borgio, on page 9 of my book, 270 Mishap 260 said, quote, a restrictive covenant can protect against unfair competition by preventing the loss of patients to departing physicians. And I have put in there, under there, the restrictive covenant that they enforced, which is that the employee will not embark on a medical practice within 7 miles of the office he formerly worked in. The court made it crystal clear that the 7-mile restriction was reasonable, that it protected the practice's competitive business interest in retaining patients, that it provided the plaintiff in that case time to regain the goodwill of its patients, and it prevented the defendant physician from using patient contacts gained during the course of his employment to unfair advantage of competition and protectable business interests. It specifically said protecting patient contacts, patients from leaving to join another medical professional. When those contacts were gained during the course of that medical professional's employment is a protectable business interest under the statute. That's what's happened here. I mean, keep in mind, Dr. Ferry has never worked anywhere except Double Chiropractic. He came there straight out of training. He had no patience.